My contribution is on a topic principles of European family law as an inspiration for lawmakers in Europe. So I'm going to talk about international things more than about Czech law. Maybe we can find some possible inspirations or answers to gaps in Czech law, which Professor Kraličková identified. Um, we can say that in a past few decades, there is a significant tendency to harmonize the law in Europe. Since the Treaty on European Union and a Treaty on Functioning of European Union brought the free movement and right to reside in a member states, then the harmonization of family law became more important and necessary because the families could be more international. It was more easy to make relationships over the states, so we can see a bigger pressure to have some harmonization in the field of family law. The European Union has already harmonized some fields of law like jurisdiction, applicable law, divorces, or maintenance, but mostly for or just for married couples or for children. There is no comprehensive harmonization of the legal regulation of cohabitation in European Union or in Europe as such. The approach of European states to legal regulation of cohabitation still varies between each state. The cohabitation is not comprehensively legally grasped in many countries. There is no complex legal regulation. Then the legal relations arising between the partners are often affected by the general rules of private law. The Czech Republic is one of such states. On the contrary, the countries in which the cohabitation has special and complex legal regulations are, for example, the states of former Yugoslavia and the Nordic states. There are some specific rules for cohabitants. Sometimes it's even equal to marriage in some questions. Although in some jurisdictions we do not find the legal regulation of cohabitation as an institute, but a certain legal framework was given by a case law or practice, for example, in Germany. We can say that there are two, or I will name two possible sources of inspiration. The principles of European family law regarding property maintenance and succession rights of couples in de facto unions, which are a product of work of Commission on European Family Law, and the Model Family Code. So this is what I will talk about in this contribution. There are several areas where we can think about accepting some legal rules regulating cohabitation. The first of all, there is a definition of cohabitation because we have to define it so we can have some legal rules or some legislation over it. So the principle says that defines the cohabitation as two persons who live in a lasting relationship as a couple. In addition, they define a so-called qualified de facto unions or cohabitations, such as unions which are lasting at least 5 years, or unions with a common minor children. There is no condition about age of partners in principles, but I think we can think about the age similar like in marriage, so maybe 18 years, but it's not defined in the principles. And the question also is whether the persons of same sex can be cohabitants by legal rules. According to the principles, they can, because the principle says it's two persons, not a man and a woman. So, so it's neutral in this area. The Model Family Code does not provide a definition of cohabitation. The second field is a maintenance. There is many questions like if the maintenance should be granted to one of the partners, when, what conditions, and so. The principle says that, or the principles does not settle maintenance during the partnership. They settle just a duty to contribute the household costs, but not the maintenance between the partners. The principles settle the maintenance just after a dissolution and just in a qualified cohabitation. So it means in a cohabitation which was lasting more than 5 years, and or there was a common minor child. Then the principle says that there is a possibility to claim maintenance for a limited period of time, so not for unlimited, but just for some period of time. And things that should be taken into account are childcare, division of responsibility over the duration of partnerships, age of a partner's health, employment, and also the marriage, registered partnership, or cohabitation, which would be the new of which would have one of the partners after the dissolution of the one. These are the things that should be taken into account. The Model Family Code has a different approach to this question. It says that partners should mutually contribute to each other the maintenance. So during the cohabitation, if one of the partners does not, then the court can order him to. And the things that should be taken into account are that, for example, one of the partners cares for a household or for common children. So it's always the same. The protection is usually granted to the fact that somebody is at home and caring for children, taking care of a house, and the other one is employed. The third area of rights and duties we can talk about is right to family home or a household. The principle says that in a qualified partnerships, the partner cannot dispose with a family home without consent of another. The court may grant the consent, replace the consent of other partner, and also if one of the partners dispose with the family home, the disposal can be annulled by a court because there was not consent. So it's a protection of family home. It's very similar as a protection in marriage in Czech Republic. The Model Family Code has a similar approach. So the partner cannot dispose, and the court may order some disposal or annul some disposal. Also, the principles and the Model Family Code agree on a fact that the court may grant to one of the partners right to use family home. The principle says that it should be in a qualified cohabitation. So after a dissolution, there can be an order to the court order that one of the partners can use the family home for some period of time, even if he is not the owner. Mostly, it probably will be the partner who cares for the children, or who is at age in which he cannot take care for himself. Another field is a property regime. The Model Family Code does not say anything about the property regime during the cohabitation, just after a dissolution. The principles settle some rules. For example, it settles that the assets acquired during the partnership for joint use by the partners are considered to belong to co-ownership. So there is a co-ownership of the things that were acquired during the cohabitation by both partners. So it's quite interesting, this idea. And also, according to the principles, each partner remains the owner of his exclusive property, and also the principles regulates the issue of property execution. According to the principles, in addition to exclusive assets, joint property may be affected for the exclusive debt of one partner only up to amount of a debtor's share in it. So there is a protection of the ownership of the other partner which is not in execution. The next question is what after the dissolution with the property, for example. Principles and the Model Family Code agrees on one fact, that there should be some right to compensation or a financial relief after the dissolution of partnership. It should be a financial contribution, or it should be a financial compensation, and it should compensate the facts or the things that happened during the partnership. For example, that one of the partners cared for a household, for children, and couldn't be employed because of that, because they agreed on that, the partners. Also for a contribution to other partners' profession. One of the partners, for example, has a shop, and then the other one works for him and helps him to grow, and then there should be some fair compensation for this contribution. So this is the same in principles and in Model Family Code. The principles and the Model Family Code says that the partners should be self-sufficient as soon as possible. So the partners after dissolution should be able to take care of themselves as soon as possible. So there shouldn't be some kind of need of other partner's money or other partner's house. It should be pushed to the moment where the both partners are able to take care of themselves. At the end of the cohabitation, according to principles, each of the partners will keep his property, and the joint owned property will be distributed, unless the partners agree otherwise, of course. So there can be a court order which will distribute the property between the partners. The Model Family Code said that, or also says that the partnership-related benefits should be equally divided, and the court may modify that. The last question is inheritance in a case of death of one cohabitants. The Model Family Code doesn't settle any rules in this question. The principles does for a qualified cohabitation. And the principle says that in a case of inheritance by law, the surviving partner has the same right as the spouse in inheritance of the estate of the deceased partner. If the partners were in the house, and also if the partners lived together in a house, which when one of them died, there is also the possibility that the partner will have right to use the apartment owned by the deceased partner for 6 months after the death. So he can take care of himself and find a new home, for example, if he is not owner or he has no rights to the flat or a house. So the principle said that in a qualified cohabitation, the spouse is included in inheritance as in a marriage, as if he would be in a marriage. So it's quite strong protection of this person who would be left here. These are the main areas we can think about. There is also many other questions, but I think that these are the most important ones. So I will end here, and thank you very much for your attention. These are the two sources I named in the beginning, and now I would like to ask the Petra Kotkova to present her contribution, and it's on the topic the right to family life in a case law of European Court of Human Rights. So thank you very much for attention, and bye for now.